Just let us know when we're ready, Tiara.
Will do.
Sorry
We're
about.
live.
Okay, great. All right, so welcome everyone to today's training. We're very excited. My name is Nipa, like I said, and I work at Housing Court Answers as a hotline specialist. And this training will be about understanding stipulations. So we'll go over what a stipulation is. We'll go over samples of stipulations. Um, And this PowerPoint will be shared after the presentation on our website, so you will have access to it. But just pay attention also because there's a lot of things that we'll talk about that's like not, we'll share samples, but like we'll go over things about on the stipulations that won't be written down on the slide. But yeah, definitely we're excited about this. So what is Housing Court Answers and how can we help? Housing Court Answers is a nonprofit. We provide housing related information. Okay. So a couple of things that we're going to go over today is what is a stipulation, differences between a non-payment versus a holdover stipulation, understanding the language in a stipulation, and what can be negotiated in a stipulation. So, sorry. So what is a stipulation? A stipulation is an agreement between two parties in a court case. So instead of going through trial and the judge issuing a decision, the two parties in a case come to an agreement themselves. So in the context of housing court, the two parties are often the landlord and tenant. Sometimes it's the prime tenant and the roommate, but generally it's often the landlord and the tenant. However, while this is an agreement made between the two parties, this is still considered legally binding as the judge will sign off on this agreement. So if you don't follow the agreement, unfortunately, it can result in various consequences based on the terms of the agreement. So often, unfortunately, it's a risk of eviction for tenants. Now, as far as the stipulation, tenants in housing court who don't speak English as their primary language, they can request an interpreter if they need one. You have to talk to the clerk to make the request as soon as possible. However, the court papers will still be written in English. Now, if you have asked for an interpreter in advance and one is not available on the court date, the case should be adjourned. So this is like when you're negotiating with your landlord or the tenant or maybe your roommate, and you may not have English as the primary language, you're allowed an interpreter. Now, there are two types of stipulations that we're mainly going to talk about today, which is the non-payment versus the holdover stipulation. So a non-payment and holdover stipulations may look different as there are different types of cases. So what is a non-payment case? A non-payment case is a case filed by the landlord to collect the rent. So as long as you pay, you stay. A holdover case, however, is a case to get you out of the apartment, regardless of if rent is being paid or not. So there could be various reasons why the landlord wants you out. So the landlord can still request or ask you to pay the back rent or the ongoing rent you owe while the case is going on. And unfortunately, they're legally entitled to it. However, just simply paying that rent, again, it won't allow you to continue staying in the apartment because eventually they just want you out of the apartment for whatever reason. So firstly, we're going to talk about the components of a non-payment stipulation because as we said that, there are going to be difference between a non-payment and a holdover stipulation. So what are the components of a non-payment stipulation? So the main thing is going to be, since non-payment is about if you pay, you get to stay and you owe back rent, the rent. How much money is owed and for which months? What are the due dates for paying the back rent? What is the due date for paying the current rent? So even if remember, you owe the back rent, but you still have to pay the rent for, the month the current month. So if someone, is owes like $5,000 for in back rent, they still have to pay March's rent. And then the months, coming up, they'll still have to pay that. And let's say you sign the agreement and you are not able to keep up with the parts of the agreement. What are the consequences if you default on the agreement? And that's what happens if you don't follow all the parts of the agreement. So sometimes people will follow a portion of the agreement and they think they're fine, but you have to follow all the terms of the agreement. Another component of a non-payment stipulation could be repairs. So what are what are the language that is involved when you're talking about repairs in a stipulation? So inspection dates. So inspection dates are the dates that a landlord comes by to check the apartment. The landlord does not start repairs on this date. Access dates or repair dates. These are the dates the landlord actually comes by to check the repair. So if you're confused about that, sometimes maybe the landlord needs to come in and check, and see what specifically is the repair that needs to be done. And they may need to hire someone. The super may not be able to do it in your building. So inspection dates are just dates for them to come see what is exactly wrong with the apartment. And then the access dates or repair dates are dates that the landlord comes by to actually make the repairs. Make sure you're available on all the inspection and access dates. It's important to wait in the apartment for the landlord and their workers, because remember, you're agreeing to these dates. So there may be specific dates listed that you say March 25th, we're gonna agree for you to come and start the repairs. So make sure you're available that day. If you're not in the apartment, then like it's not gonna be the landlord's fault, it's gonna be your fault because they came by. So things like that. Now, make sure you include all the repairs that are needed. So if you have repairs that are needed, but you don't list them in the stipulation, they will not be addressed. And you want to try to be detailed, but to the point at the same time. So an example is sink in the kitchen leaking. Sometimes like you'll see stipulation where it says like kitchen. Okay, what's wrong with the kitchen? You want to pinpoint, and we'll talk about that. We'll give examples of that later examples that we show of stipulations. You want to avoid weak language, like the landlord will inspect and repair if necessary, which could result in landlords not being held accountable for not making repairs. Because if necessary indicates that who is making the decision of whether it's necessary or not. It's the landlord, and they could deem it not necessary. So if you want to bring it back to court and say, hey, they didn't follow their part of the agreement, well, the landlord could just say, hey, it wasn't necessary. So you want to avoid language like that.
Judgments and warrant. Money judgment allows the landlord to collect money. Judgment may appear on your credit report. If your stipulation has a judgment, you could ask to include language that allows the judgment to be vacated when the money is paid. We will cover this in some of the stipulation samples that we have, which means judgment and warrant, which means if the tenant defaults on the agreement, the landlord or his attorney does not need to go back to the court to get him evicted. Possessory judgment. Landlord can evict you if you don't pay it on time. Stipulations can have both money and possessory judgment or just one. We will see example of stipulations like these on the next couple of slides. All stipulations do not have a judgment. Some stipulations have deadlines that do not include judgment and require the landlord to bring the case back to the court if the tenant defaults. Some of the stipulations actually are very good because they work in favor of the tenant, which allows them additional time to pay off the arrears. Next slide, please. Judgment and warrants continue. If stipulation includes either judgment or warrant, landlord can hire a marshal who can evict you if you don't uphold the terms of the agreement. What this means is if there's a judgment or warrant, the landlord goes, hires the marshal, marshal comes to the court, requests a warrant to evict, and could serve you if you don't uphold the terms of the agreement, which either be paying the rent on time or moving by the due date. If there's no judgment on your stipulation, the landlord will have need to go back to the court to get one before he or she can hire a marshal to evict you. Remember, only a marshal can evict, not the super or the landlord's attorney. Next slide. Other things that might be under stipulation: require landlord to give you a renewal lease or lease in your name. If it's in a rent stabilized apartment, the landlord has to renew your lease regardless if you own rent. Fees: while you cannot be evicted for fees, you should try to resolve them in a stipulation, as landlord can come after you in civil court and sue you for these legal fees or any late fees that you owe. Rent breakdown: always ask and have the landlord that will provide this by what date. The rent breakdown is very helpful because it actually lets you know if you and the landlord are having a discrepancy. It lets you know exactly where the discrepancy is coming from, where the money actually is owed. And process your recertification paperwork. A lot of times, some people are in court because recertification were not done in a timely manner. So in stipulation, you would see tenant will be allowed 30 days to go back to the office to recertify their Section 8 or their subsidy. Next one, please. Other things that might be in a stipulation: tracing a money order. There will be a date. Tenant has until end of March to trace money orders. So this is always good to make sure they put it in a stipulation, how much time you have to trace the money orders. A working contact number, email for landlord if you have trouble getting in touch with them. A lot of the tenants are saying we are not able to get in touch with management or the super. So it's good to write this on the stipulation. What is the best number or email to get in touch with someone in management? Rent abatement: must negotiate for it in a stipulation and request it when you file answer. If a tenant goes to court and put in his answer, he or she should request in his answer that they're seeking a rent abatement. If it's not requested in your answer or in the amended answer, it might not be negotiable. Make sure there is a clear definition of when and how these tasks will be done. Next. I think that's yours, Nipa.
Oh no, I think that's yours. The holdover, sorry.
Oh, holdover
Oh,
stipulation components. The stipulation will depend on the reason for the holdover type of case. No grounds holdover: if you have no lease and you're not the rent regulated. What happened? And you are not rent regulated, the landlord can bring an eviction case to get you out without providing a reason. It does not matter if rent is being paid. Holdover based on the violation of the lease or the law. If the landlord is alleging undesirable conduct, the stipulation may contain a probationary period. The agreement might be that you will do something like pay the rent on time or stop doing something, letting your bath overflow for a certain amount of time. The stipulation will say what would happen if you default or break the agreement. Next slide, please. Holdover stipulation. Time to move out. The stipulation will say that you have to move out by a certain date. Make sure that if you sign an agreement that you are going to move out by that day, that you're able to comply by that day. Rent. Do you have to pay rent or use an occupancy every month until you move out? Or do you have to pay back rent owed? The stipulation should say what rent must be paid and what will happen if it's not paid on time, if you default. In some of the stipulation, we will see what happens if a tenant agrees to move out, rent is waived, and they default and not moving out. They will probably be responsible for paying those rent arrears that were waived. Condition of the apartment. Can you leave furniture in the apartment or does it have to be left empty and broom clean? Are these services that need to be provided before the move out date? These are things also that we will see on stipulation that are written, and tenant have to comply to these agreements. Next.
I can take over here, Gina.
Okay.
Okay. Other things that are holdover stipulation. So remember, holdover is basically you have to leave at some point anyway, because the landlord doesn't want you in the apartment. Fees. Maybe late legal if you pay extra fees for an air conditioner, a washing machine, parking fees. Make sure the stipulation defines if the landlord is asking for any of these fees. There may be legal limitations on the type of fees they can ask for in the housing court case, but a lot of times they can take you to court for it, like in civil court, for these fees because they couldn't get it in housing court. So you want to maybe see if they're willing to waive these type of fees or if they want you to pay it. So it's clear, like if they try to take you to civil court for it, like, hey, your defenses, like if they've waived it or something like that. Security deposits, how and when it will be returned. So there are laws about how a time limit for returning security deposits. Um, but also if you want to get it in the stipulation, maybe you want it sent a specific way, maybe you want like a check or something like that, instead of like maybe you just want it Zelle. So maybe these are things you can discuss. A walkthrough. A walkthrough is very important when you're moving out because that actually kind of relates to security deposit. So when you're moving out, what you should do is you should schedule a time for both you and the landlord to be present so that you can inspect the apartment. The thing with security deposits is that when you are moving out, you should be given a chance to um correct the issue. If there's like a repair or something that's needed, and the landlord, when you do the walker, the landlord may say, like, okay, there's something wrong with this. So you should be given an opportunity to fix that before you leave. So that way you can get your full security deposit back. Now, if you don't have the walkthrough with the landlord, that's going to be difficult. If if you and also like Gina said before, you may have trouble getting in touch with your landlord. So if you put it on the stipulation, it's a court order. So okay, we already scheduled it. This is when you're gonna come, and we're gonna both look at it together. And then that way you don't have to worry about, oh, I can't get in touch with the landlord or the super. And then you may be given an opportunity to fix it. And then you're both present for like how the apartment is left. So the landlord can't then turn around and claim like, okay, this was there. Like you guys were both present. Also, just in case like the landlord doesn't show up, because these are ideal conditions, but things happen. You should take pictures, videos of when you are leaving, so that way, you have proof. So if they come back and say something and you're like, no, that's not how I left it, it's not just your word against theirs. You have video or a picture evidence of it. Um, Turning over of keys. The manner when you turn over keys, you're turning over possession. So um, and that is when your agreement to pay the rent or use and occupancy generally terminates. So it's very important that you have proof that you turned it over. And so maybe you get a receipt. Okay, I turned it into the super and they gave me a receipt. This is proof that I actually moved out on this date. Because then if they say, hey, no, like you actually stayed until is there's dispute over the months that you were in the apartment or when you had possession because you didn't turn over the keys, you have the proof. Who are you going to send it to? Are you going to go into the office? Again, most people aren't, unable to connect with the landlord or the landlord's attorney, uh, or, just maybe the super you generally speak to. You may have trouble communicating with them. So who do you turn it into? Is it the office or the landlord's lawyer, the super? Sometimes in managements, once it's in like court, um, the management won't speak to you. They will only have you speak to the landlord's lawyer. So that may be an issue in you trying to turn over the keys to the super. So yeah. So those are things you want to specify. The clearer you can be in your agreement to move out or, to pay the rent or things like that, the better it is for you. So now we are actually going to get into some language that is in a stipulation. And this is when, it's legal language we're dealing with. So that's when people tend to get confused about or just don't understand it. And they unintentionally violate the agreement, even though they think that they're following their agreement. They have all intentions of following their agreement. So current rent provisions, that is one of the main things that we see all the time where people tend to violate the agreement and they don't realize that they're violating the agreement. The current rent provision means that any payments made by a tenant will be applied to the current month rent before being applied to rental arrears. So that means that if you make a payment, so you make a payment of like $5,000, well, you make a payment of $2,000. and you owe $5,000 and your rent is 1,000 a month. That means first and we're in March right now. So first they're going to take out the $1,000 for March's rent, and then the 4,000, the remaining 1,000 that you paid is going to be applied to the back rent. So people don't realize that. They think, okay, I made a $2,000 payment, so I only owe 3,000. No, you only made a $1,000 payment towards the back rent, because the current rent clause says that any payments you make will be applied to the current rent. When April 1st hits, that means you're a new month. So it's any payments you make will be first applied to the April rent first. So you have to watch out for this type of language on your stipulation. Forthwith without delay. So immediately. So in terms, a stipulation may state warrant may issue forthwith, issuance of warrant forthwith. You may have a payment date, but forthwith language allows the marshal to request the warrant right away. What that means is that in housing court, there are two permissions that is necessary before you can be evicted. First, the landlord requests the permission, and then the marshal themselves have to request permission to the courts to come and give you the marshal's notice. What the forthwith language allows is that basically the marshal can submit that request right away. They don't have to wait until the payment date is over. It doesn't mean they can evict before the payment is over. It just means that they can put in the permission to get the notice and come give it to you. Because that permission can take some time. So this allows them to just put in the permission to come and give you the notice. But the notice will state like the earliest eviction date, and that date will be after your payment due date. Other language, warrant may be served before payment date. Marshal can serve but cannot evict until the payment date has passed. Warrant shall execute on marshal's notice. That means the marshal can come and serve you the notice. Execution stayed for respondents to pay. So I mean there's a hold until you pay. These are different versions of the same type of language, but there's like a lot of the stipulations we'll go over today. You'll see the same theme. It's just there's different ways of writing it. These are some common language. So included, you agree to pay. Reserved means the judge won't make a decision about it today. So the judge will make a decision about it later. Waived. So the landlord has agreed to like not let you pay this. They may be legally entitled or whatever, but they're letting you agree to not pay. There may be conditions attached to that, and we will go over it. Put off until later in the case. It means we're not dealing with it today. We'll deal with it at another time. Severed. So this is when we were talking about the AC, the legal fees, the late fees. Under certain conditions, they can ask for them in housing court. Usually what's when you're evicted, but generally in housing court, you cannot be evicted for legal and late fees. It's different when you're evicted, but these severed means that they're not waiving it, but they just are not asking for it in this case, or they're not dealing with it in this case. However, they can take you to civil court for them. And then plenary action, like we said, it's a different way of saying that we're not going to deal with it in this case. We're going to deal with it in civil court. And so we're reserving our right to sue you for this in civil court. With prejudice. So with prejudice means that someone cannot bring this case back to the same court for the same issue. It's rarely that you'll see with prejudice in housing court, but it does happen. So if your landlord took you to court for non-payment of rent and, they just were like, and the case was just, or in the agreement says with prejudice, that means the case is being dismissed or discontinued, and they cannot bring you back for that same amount of money to housing court. So that's great for you depending on like what the with prejudice reason is. Without prejudice means they can just refile the same case. It's a new case they have to start, but maybe there was an issue with the filing for some reason, they want to dismiss the case, or you want to dismiss the case and you came to an agreement, but you can just refile. NAR, NAP, it's an acronym. Basically, it means no appearance by respondent or petitioner. So depending on who has filed the case, you could be the respondent or petitioner. Usually in a non-payment or a holdover case, you, the tenant, are the respondent. The petitioner is, in a non-payment or holdover, is the landlord. Or in case you have a roommate, you are the petitioner. You are the leaseholder, are the petitioner. And then the R indicates who didn't appear in the case. So it means you had a scheduled court date, but for some reason someone didn't come. And then I think you start, Gina, right? Right?
Okay, yes. So this is a non-payment stipulation, which details what previously was mentioned about due dates for paying back rent, due dates for paying current rent. It also covers repairs, rent ledgers, lease renewal, recertification, and other interesting things. I don't know if you're able to see this, but it says petition amended to include all rent through June 30, judgment in the amount of $7,000. As you can see, the payment plan is a nice long extended payment plan. They have to pay $1,100 every month towards your arrears. And it also says above payments does not include rent, use, and occupancy from July through December. We highlighted monies received should first be applied to current rent, use, and occupancy, and then the arrears. A lot of times what we see is the tenant will be paying and it will be applied to the arrears. So the tenant feels, and it looks like the tenant is not paying the current rent because everything is being applied to the arrears. So it always will look like the tenant is not paying anything at all. So you always want to make sure that it's something clear, that the money you pay will be first applied to the current rent and then the arrears. With this plan here, this tenant knows exactly how much she has to pay towards the arrears and that she needs to pay her current rent by a certain days. Also here, it tells you about the repairs, which is payable, the recertification. It also mentions here recertification without prejudice, and also the lease renewal. And it tells you how many days the landlord has to do the repairs and the access date. So this is one of the stipulations that we have talked about. Next slide, please. In this stipulation, we highlighted via click pay. And the reason we highlighted this is because sometimes tenants have to pay via on the internet or on the website. So sometimes they get blocked. And that's the only way that they could pay. They don't have the time to go get a money order or don't have access to a bank account. So this is a way easier. So we highlighted via click pay. If you want to pay in a certain way, you have to make sure this is put on your stipulation. This is the way I want to make sure that my renters get paid every month. And here the stipulation says January, by what day, February, by what day. So it's actually letting the tenant know that the payment is due no later than the 15th. Anything late after the 15th could be a default. Next, please. And this one here, respondent acknowledged owing $7,849.31. After paying $1,500 in court, respondent was provided with additional breakdown in court. So they got a breakdown. Final judgment of $7,849. We highlighted warrant to issue forthwith. What this means is after the attorney signed this stipulation, he has the right to go and hire a marshal. Marshal comes back to the court and requests a warrant to be able to evict this tenant if he or she defaults. Another thing we highlighted was warrants to issue after service of marshal notice immediately following any defaults of payment, which means even though this tenant was giving a nice payment plan, if they default on any payment plan, the landlord, the marshal, who evict this tenant if he defaults on any of the payment plan. So she might just be missing 1 month, and because of that 1 month, he or she might get evicted. So you got to be careful with these kind of languages. And then satisfaction of judgment upon payment in full and request. Anytime a tenant gets sued in court, it comes up in your credit report. So this is something that you want to be written on your stipulation. Upon payment, judgment will be vacated. So it's something that if in the future tenant had to go apply for another apartment or look for or buy a house, this doesn't show up in the credit report. So the last one is something that a tenant always wants under stipulation if there's a judgment, that there will be a satisfaction. It will be vacated. Next slide. And this one, the tenant owes $22,000, payments due by the end of November, and owns 22, ends by and paid by the end of December. My fault. It says, in the event respondent default in payment, petitioner may restore this matter to the court calendar upon a date written notice for final judgment and warrant forthwith. So this one doesn't have a warrant. He did not get a warrant. But if the tenant defaults, the landlord is the one that needs to go in and restore the case. The landlord's attorney will put a motion, which tenant calls an order to show cause. And then it's asking the judge for final judgment and a warrant to be able to evict this tenant. In the bottom part, it says, in the event of the default of any of the above scheduled payments or a default in paragraph 7 herein, the entire amount should be accelerated and become due immediately. Petitioner reserves the right to legal, late fees, marshal fees, in addition to any other fees or rent allowed in the lease. This is a pre-written stipulation. So this is something that tenants might want to be scratched out. And the reason is because if he or she defaults on the payment, the landlord's going to put in a motion, but the landlord should not be allowed to get late or legal fees, even if it's in a different civil case in a different action. So this is something that sometimes tenant does have the right to say, can we wipe this out? Can you just erase it and not be in the stipulation? The bottom part is also letting you know by what time the workers should arrive. The workers should arrive by 11 a.m. In case the workers are not there, usually it's written down that the tenant doesn't have to stay there, go to work or follow through with whatever they need to do. But the workers are supposed to be there by 9 and leave by 5 to do the work. And here it mentions all the repairs that needs to be done. Next. And this one is basically similar to the previous one. We highlighted, it's just worded differently. It says, in the event of the default on any payment hereon, the petitioner may move for entry of a judgment of an 8 days written notice to tenant, which means the landlord's attorney has to file a motion to restore the case to the calendar in order to get a final judgment. This kind of stipulation like this actually allows the tenant more time to get his or her rental arrears from the charities or from the Department of Social Services, whichever department is going to be assisting them in the rent arrears, with the rent arrears. In the event respondent defaults on the payment set forth above and the case must be restored, petitioner may be amended to include additional rent and charges through the return date of the motion, and petitioner reserve his claim for reasonable attorney's fees. So tenant owed $1,623. Now, June, July's rent, has also accumulated. So the landlord has the right to attach those 2 current month rent that he also defaulted. But then also the landlord is asking for reasonable attorney's fees too. So this is something that the tenant needs to read and be careful about what he or she signs. They could also ask, can this also be crossed out from the stipulation? A stipulation is an agreement between both parties. So tenant does have a say in what they want written under stipulation. These pre-written stipulations are the landlord's attorney that carry them. The tenant could ask the court attorney, can I get a stipulation? So he or she will have the input on what it is that they want on their agreement. Next slide. This one is no judgment and no warrant. So this one he has to pay by, this is all the rent they owe. They have to pay by the end of June. It says, upon default, any payment hereon, the petitioner may move for entry of final judgment and warrant eviction on a 5 days written notice to respondent. If you notice, the previous 2 stipulations says on an 8-day notice motion. So this one is similar. The only thing, it has 5 days. So if they default within 5 days, which would be probably around July, the landlord's attorney is going to come file a motion saying tenant defaulted and asking for a final judgment and a warrant to evict. So tenant has to be careful. And it also stating no repairs at this time. So that means this tenant has no judgment, no warrant, and has no repair. So then he or she will have to wait for the landlord to restore the case. So this is actually allows them some additional time to get the rent arrears. Next slide. Final judgment of possession enter in favor of landlord against Jane Doe. Issue of the warrant forthwith. Execution of warrant stay through July for Jane Doe to vacate. Responded to vacate. Vacate means to leave the apartment broom clean condition. Broom clean condition means nothing, no garbage should be left in the apartment. No soda can, no littering or anything, no. Free and clear of all occupants. Meaning, if you move in with a friend, if you move in and you invite your friend or your sister over, they also have to move out. Any property left in premises will be deemed abandoned. So if you move out, if you leave a sheet, a coat, anything that you leave, it's going to be considered abandoned and the landlord would dispose without any liability, meaning you cannot come back and sue them saying, but I left my bed, or I left my phone charger, or I left the TV, even though the TV wasn't working, and try to sue the landlord for it. Jane Doe represents being sole adult occupant of premises and will not sublet, assign, permit any person to possess apartment upon the full warrant to execute by service of martial notice. This looks like it's a holdover case. The person agreed to vacate. The person alleged there's no one there. If this person leaves and someone is there, person might be responsible. If any rent arrears were waived, the person leaving someone else in this apartment might be responsible for the rent arrears the other person accumulates. So tenant agreeing to leave the apartment have to be very clear on what they're signing and being able to comply with what they sign, especially in a holdover case. Next slide, please. Petition amended to include a rent due. So that this tenant paid money order, they wrote the number, if they wrote down how much the amount was reduced and how much they owe through the end of September. And also it reads, the tenant will pay this amount plus October's rent. This is what the tenant is agreeing to do. They need to comply. And it says here, petitioner reserves the right to seek any applicable charges, security, late fees, legal fees, which are not included in the judgment amount at this point in this proceeding. So he's able to get security, late fees, or legal fees in another plenary action proceeding, which will be civil. Tenant have to be very careful about agreeing to this because if there was any late fees, or if your lease writer said that if the landlord had to file a case against you, you would be held responsible for legal fees. Tenant have to be very careful in signing something like this. Like I said it before, the tenant have the right to say, can this be crossed out? Can this be removed? So this is something that the tenant have the right to request. Next slide, please.
I can take over.
Thank you.
Okay. Yeah, so we can talk about like the highlighted section. And again, this is an example of a pre-written like stipulation agreement. So what I mean by that is the landlord's office usually has like a pre-written form that their office uses. You don't have to use this form. So you see everything is typed out. You have the legal right in court to say, I don't want to use the pre-written form. I want to use the blank court ones. The courts have them. So it tends to have this language written out, and then you just have to make sure you cross it out or you negotiate, hey, this should be crossed out. But yeah, you have the legal right to say, I want to use the blank one. And you can write it. It doesn't have to be the landlord or the landlord's attorney writing it. You can write it. Sometimes the court attorney will write it, things like that if you guys are arguing, but you have the legal right. Um, And we use the real life examples. So as you can see, the writing is a little bit difficult, but these are the real life examples and that's how they are. You can clarify, like, hey, what does this mean? If it's so messy, you can just say like, hey, I need you to write like neater because remember, you may need to refer back to this agreement to be like, okay, what did I sign against? Sometimes, we're understanding things and then or just we forget and we want to refer back and then we can't read it. I know maybe like even this one and maybe the written portion may be like difficult for people. We kind of like see so many of these, we kind of tend to pick up the language, but for the average person, it's not like that. So yeah, you can say like, okay, well, I need you to write, neater, or I'm gonna write it because I can't understand this. Um, in this one, here, the highlighted section, it says petitioner consents to one order show cause motion for good cause shown by respondent. So in the context of this, what this means is that they agree to make that $9,450.34 by April 10th. Now, if they don't, what that means is that you have to come back to court and request an order to show cause. An order to show cause could be, I wasn't able to comply with this agreement, so I need more time, and then you have to ask that to the judge. You are allowed to do that as many times as possible. However, by signing this agreement, this specific stipulation, they added a clause that says you can the basically petitioner consents mean they're agreeing to allow the tenant to get one order to show cause. So they're agreeing to that. However, this language, you can make as many order to show cause requests as you want, and it's up to the judge to grant that request. It's not up to the landlord. The landlord will come back. When you make an order to show cause request, what happens is you go and you request that to the judge. And then the judge says, okay, I approve it for right now. And then we're going to schedule a court date so that your landlord or the landlord's attorney could be present. And they have to be given a chance to argue against it if they don't want it. Because when you go to make the order show cause, the landlord or the landlord's attorney is not there at the time. But then let's say you get an extension and you still need more time. At that point, you've signed an agreement that says, I'm agreeing to get the landlord agrees to one, so it works against you. So you can ask like, hey, this be taken out. Like you shouldn't control how many orders show cause, I'm gonna consent to or the potential how many ones I can file. It should be left up to the judge. So you can ask for this to be taken out. Okay. So now right here we see that this is a holdover case. So basically, respondent appears to waive all jurisdictional defenses to this proceeding. So jurisdictional waiving of the defense, you have to make sure it's the proper court and the proper venue. So if you live in Brooklyn, you have to file this case in Brooklyn Housing Court. So basically what they mean that this is the proper court to file it. So someone in Manhattan cannot file a housing court case in Brooklyn. So when you're waiving the jurisdictional defense, you're saying that, okay, this is the proper location and the proper courthouse I'm in to be able to file this case. So then I cannot bring it back and say, hey, you didn't file this in the proper court. Because you're waiving your defense to that. Now, right here it says execution stayed through September 15th. So basically, you're not there, you won't be evicted until September 15th of 2023. And then respondent to surrender possessions free of all persons and property. Respondent represents that no other adult resides in premises. Okay. So this is very important because a lot of times what happen is that people will leave the apartment, but they will leave someone behind. So let's say you moved in with your partner and then you were the leaseholder. And then during you had a breakup and then they refused to leave. But you are the leaseholder and you're taken to court and you sign this agreement. Now you leave as per the agreement. So by September 15th, you left. However, your ex-partner is staying there. You agree to this agreement that you're going to leave the apartment empty, not just of property, but also people. So if they stay behind, you're breaking the agreement. And you're also saying that nobody else like lives in the apartment. Now, you guys may be thinking, who would sign that? But you know, things happen. Sometimes people just assume they can get the other person out by, showing the course and they'll leave and they just don't leave. So if you're going to sign this agreement, make sure you know what you're signing. Um, Also, if let's say you have a roommate and then you don't leave, that means you're violating the agreement. You said when you turn over possession of an apartment, you have to leave it how you found it. So if you came in and you got a roommate after you signed the lease, and when you moved in, that apartment was empty. So you can't just leave and then your roommate's still staying there. That means the landlord doesn't have possession back of the apartment. So you are not turning over possession until everything is empty. Um, and then the parties reserve their claims and defenses as to arrears and future use and occupancy. So this is not the best type of stipulation agreement for a tenant because the thing is what they're saying is that they are reserving their rights to ask for back rent and then future use and occupancy. Use and occupancy is a term generally used in court when the lease has expired and there's like no formal agreement about what the rent is technically. Um, so basically they're saying that we can still discuss how much the rent should be. And this is basically if you violate the agreement, because if you see here, it says respondent consents to 4,800 due and owing for March through June rent at $1,200 a month. Now, let's say, so that's agreement for the back rent, and then let's say, you're paying they didn't talk about an amount that should be paid. We don't know in this situation if the lease has expired or not, but they didn't talk about an amount you should pay for if you violate the agreement. So now you may have to discuss it in civil court. Um, and then petitioner to provide dated receipt for keys, which is super important because again, sometimes you get a receipt. Is it dated? It just says, you know, hey, you've returned the key. What date did you return it? If the agreement is that you're gonna leave by September 15th, you don't want a receipt is it not dated. You want something that says, okay, I left by this day or I left even earlier. So you have a dated receipt. So that's like pretty helpful. And then the other thing I just want to mention is right here, it says earliest eviction date, so September 18th, but then also says execution date through September 15th. So this can be a little bit confusing. So there's two different dates of when you're essentially supposed to have left by or the date you can be evicted. If that's confusing to us a little bit. So it may be confused to someone who doesn't do this all the time. So definitely like say, hey, this was confusing. We need to clarify. What is the date I have to leave by? So this is an example of a pre-filled out agreement form. So another holdover case. So warrant to be issued forthwith with execution stayed through and including February 1st, 2024. Final vacate date. Respondent shall vacate and surrender the premises on or before the vacate date in good and broom clean condition and free from damage, debris, and any occupants, pets, and possessions. This is a final date. No default shall be de minimis. The surrender of the premises shall be done by respondent returning all keys to the premises, including the building key and the mailbox key, to the petitioner, who shall conduct a walkthrough and provide a dated receipt. Anything remaining in the premises shall be deemed abandoned and discarded without liability. Security deposits, if any, are forfeited. This is kind of good in that it does make it a very clear, it's very clearly laid out how things should be. So, um, basically, how are you supposed to return the keys? And they specify, we also need the building key and the mailbox key back. So that's good. So you know exactly what you have to return in order to turn over um the possession. And then it says that the landlord or the landlord's attorney or whoever is going to be, they're going to conduct a walkthrough and provide a dated receipt. However, just remember, sometimes you have trouble getting in with the landlord. So maybe what I would do to improve this is I will say, okay, well, we're gonna schedule a time, a specific date for you to do a walkthrough. That may be difficult if you're searching for an apartment and you don't have an apartment ready yet. Now, if you have an apartment that's ready and or you have somewhere to go and you know you can be out, maybe it'd be helpful to get a specific date. Okay, April 25th, I'm gonna move out by this date. We're gonna schedule April 25th, and we're gonna schedule from 12 to 1 p.m. that you, the landlord, or the landlord's representative, whether whoever that is going to come to my apartment and we're going to do a walkthrough. So, and then you're going to provide me a receipt. I will turn over the keys that day. That would make it better. Um, and then you also agreed that you're going to keep it in broom clean condition, free from damage, debris, and occupants, pets, and possessions. Um, and then they also said that if you leave anything behind, we're gonna be able to throw it out. So if you leave like, if you unfortunately forgot something, maybe you thought you took like a file, an important file that you needed, and they throw it out, that's not gonna be your responsibility. That's not gonna be their responsibility because you agreed to that. You turned over the keys and now I just threw stuff out. So you can't sue me for it because you agreed to it. And then security deposits, if any, are forfeited. Sometimes people will make that agreement because, maybe you owe rent and you're like, okay, just use my security deposit against the back rent that I owe. Um, if you don't owe rent, you may want to contest that part. But if you owe rent, like, and you don't have the money, then maybe that's a good thing for you. So whatever works for you, just see that like it's something that will benefit you. Responded to leave the premises free of all persons, belongings, or debris. Landlord to keep security deposit, if any. So yeah, this is another version of it. Any remains property shall be abandoned. But yeah, this is just another version, and we're just showing like how they wrote it. It's not as like thorough, because especially with the broom clean language, most people don't know what that means. But on the other one, if we see, they kind of went to more specific, free from damage, debris, and any occupants. The damage part is a little, concerning because what if there's not just natural wear and tear? Do they want to come back? So maybe that's something you want to think about. But debris, like if you want to, do a nice cleanup or anything like that, yeah, just like sweep and things like that. And then landlord to keep security deposit, if any. Yeah, so maybe for some reason you didn't do a security deposit. Most people do, but yeah. Now, this may be a little bit difficult to read, but we'll read it out. In the event that the respondent vacates the subject premises free and clear of all occupants by June 30th at 5 p.m. and in good condition, less ordinary wear and tear, the judgment shall be further reduced by the sum of security in the amount of 3,100. This is so generally, while you are living there, that use and occupancy we talked about, the landlord is entitled to money while you are still in the apartment. So unfortunately, you can't live there for free and you may owe back rent. What this means is that if you leave by June 30th and they gave a very specific time, 5 p.m., for some reason they wanted you out by 5 p.m. Maybe they want to have their staff confirm that you actually left by 5 p.m. It's not normal generally to see that, hey, it's going to be a specific time. So if you leave at 5:30, you're kind of breaking the agreement. So maybe that's not helpful to you. Um, and you can be like, hey, let's cross it out. But if you know you're going to be out, then, just, I guess, keep that in there. Um, but what that means that if you agree to pay a certain amount of money. So in this here, we see that above does not include so in the sum of $3,146 per month, and then they have to pay the 1,500 by May, June 30th. However, if they leave by June 30th, that means that the landlord is agreeing to waive the $3,100. So this may be great for you because again, they can come after you for any back rent owed in civil court. So they're saying, hey, we'll give you a $3,100 break. That may be great for some people, especially like, if they have a place to go to. $3,000 is a lot of money. Um, yeah, other people, they just don't have a place, so it may not make a difference. But then you got to watch out because there's consequences if you don't leave by June 30th. Now, in the event the respondent vacates by June 30th but fails to adhere to the payments set forth upon paragraph 6, and all stays on the enforcement of the money judgment shall be deemed null and void, and the entire balance shall become due and payable. So there's a section. So let's say you leave by June 30th, but you didn't follow the payment agree. So here it's not just I can pay the May rent anytime. They specifically said, I need you to pay the May rent by May 15th, June rent by June 15th. So even if you leave, but you don't follow the payment agreement set out, and then right here too, there's another payment agreement. What that means is then it cancels out any money that I'm waiving for you. So the 3,100 we talked about before, that means we're no longer waiving it. And now you have to pay all of it. So people, when they're considering leaving or considering these agreements, those are dates, those specific details really make a difference. So you want to think about this May 15th. Maybe you could say like, okay, I'll pay May's rent, but maybe I don't want to do it by May 15th. Most people get paid, twice a month. That first check, maybe it's not enough for you to make the full payment, but you get the second check. But the second check doesn't come on May 15th until May 15th. So maybe you have a subsidy. A lot of subsidies, they make payments twice a month, So May 15th is a date that the subsidy may be paid by, um, or maybe it's delayed or for whatever reason. Those are things you want to watch out for. Because now they're not agreeing to 3,100 anymore. Yeah, so this is an example of a stipulation you may not be able to read properly. Um, so again, you can just say, hey, I need you to write, I can't read this. I need you to rewrite it. Um, so this is the issue forthwith language we talked about. So remember, it means that they can serve the marshal can, if they get permission from the courts, they can come and give you the document. And the earliest eviction date will be October 2nd. They can come and give you the document, but they cannot evict until the October 2nd deadline. Why they put the forthwith language is that essentially what it means is that October 2nd comes and you haven't left or you haven't made the payment arrangement that you agreed to. That means October 3rd, that could be the first day they can evict. So when you receive a marshal's notice, there's a 14-day period before the eviction can take place, and it'll tell you on the marshal's notice. So let's go by like an even date. So let's say your earliest eviction date is October 2nd. Um, that means that you would have had to receive, let me go into October 2nd. Let's see. So the earliest date you can receive it, you would have had to receive it by September 18th. Because the earliest day you can be evicted is October 2nd. So you get the marshal's notice by September 18th, and then um October 2nd, you don't make the payments. October 3rd, you can be evicted. What happens is if that forthwith language type is not there and there's no other language that's allowing them to send you the marshal's notice before, that means they have to maybe have to go back into court and then request that notice. So you get a little bit more time to make that payment agreement. So a lot of people with one-shot deals or assistance, things are taking a very long time right now. So maybe by the time that, they get the marshal's notice, your one-shot deal has processed. So now you can go back to the judge and say, okay, judge, I paid it off. Look, the check was sent late, but I paid it off. So, that's going to give the judge a reason to say, okay, well, I'm going to put a stop to the eviction because it's paid off now. Or maybe you have sometimes you're waiting on like an interview or decision to be made and you just need extra time. That's what not having that forthwith language gives you. It gives you time. And then right here, petitioner agrees to waive all arrears alleged due through vacate date totaling 9,600. Now, they are saying that if we read that first, stayed and including September 30th. So there's a date that they agreed on the vacate date by September 30th. Now they are saying that there's $9,600 that's potentially owed, and I'm agreeing to waive it if you leave by the September 30th date, which is, at first it sounds amazing. Yeah, like $9,600, I'm out. But the keyword here is alleged. What the language there means is that the landlord is claiming that the alleged amount of arrears is 9,600. Why is it alleged? Because then maybe they could come back and say, well, no, I agree to wait the 9,600, but you actually owe 12,000. So the alleged is not helpful. So you could say, okay, well, you could say, no, I want that crossed out. Or if we don't know how much the amount is, like, let's just look through it right now. Let's get to a clear, defined definition of what I actually owe and what you're gonna be asking me to waive, what you're like agreeing to waive if I leave by September 30th date. So yeah. Upon default, all stays lifted and waiver of arrears is void. So what that means, again, is a different way of writing the same thing. If I don't leave by the not the September 30th, the October 2nd date or the September 30th date, depending on the total agreement, that means he's not letting me go of the 9,600. So that means I now have to pay all that and they can come after me. This alleged word is also important because remember, this is helpful in civil court. So if you sign this agreement and let's say it didn't say alleged and you leave by the due date that you guys agreed to, that means if they try to come after you in civil court, you can present this agreement like, hey, we had an agreement in housing court and they agreed to waive this rent for me if I left by this date. So this stipulation a stipulation, you signed the agreement, but remember, there's the housing court judge that's also signing off on it. So it's a valid court. It's essentially a court order. It's just you guys are signing to their agreement as opposed to like the going through the trial and the judge making decision. So it does have power. It's just, yeah, you guys negotiating. So now we're gonna get into a little bit like stipulations that talk about repairs. Petitioner to inspect or repair as required by law the following alleged conditions: arriving on these dates, 9 a.m. to noon, working no later than 5 p.m., completing all work within 30 days of start. So there are good things about this. So however, and once again, we deal with the word alleged. We don't want alleged. There are conditions. You know yourself if there are conditions, because the one thing is the conditions were listed out. If you see that squiggly writing, the specific repair conditions are written out. But then the landlord is saying these are claims that you're making, but I don't know if they're to be true yet. You as a tenant know what your repairs are. You live in the apartment. So I'm gonna um the alleged conditions, I would want that out. Now I'm agreeing to inspect and repair. So on here, the thing is maybe you would want to say what dates are you coming to inspect and what days are you coming to repair? So remember, inspection is when they come to see like what days, what repairs are needed. So maybe I want to specify, hey, what day are you coming to inspect and when are you going to actually start the repairs? And then 9 a.m. to noon, working no later than 5 p.m. So they're not going to be there past 5 p.m. and then completing all work within 30 days of start date, which is okay. But if they start the repairs on 11/21, that means it's the repair days 30 days from 11/21. Maybe you want to have a specific day um that the repairs are supposed to be made by. Maybe like instead of saying within 30 days, that may be helpful to you. Also, remember, you want to establish dates that they're going to come and do the repairs because a lot of people are working. So the landlord may say, "Oh, okay, I'm going to come back on a Monday, 11:30, but you work on that Monday, and you're like, I can't. But then they could come back and say, we tried to make the repairs. You didn't let us in. So maybe you want to establish specific dates that you're available. Maybe you're off on every Monday. So you're like, okay, landlord can come in on Mondays, things like that. Also, it's near, if we look these specific dates, it's near Thanksgiving. Maybe you're out, you're going to be away on vacation, things you won't be home. Hopefully, I don't think they're trying to make it, but who knows, right? The 11/21 is close. Some people go away earlier. So these are things you need to consider. You know your life better, and you should try to push for days that's going to work for you, not just them. Um, so right here, it's another. Without admitting to allegations, petitioner shall repair as required by law. So remember, they're not saying that these repairs are required. They're like saying, hey, no, we're not saying that, these are definitely necessary. And then we're saying that if it's required by law, then I will make the repairs. But that is a little tricky because they could come back and say, oh, well, it's not required by law, but you may need certain things. Like that's just like weak language, and we want to avoid. We want to be very clear. We want to be essentially firm in our language. Um, so this is a little funny one because to reinspect refrigerator, petitioner has a recent receipt from the technician confirming that the refrigerator is in great working condition to fix the rubber seal around the refrigerator. Okay, so how is it in great working condition if the rubber seal is missing? So your food is spoiling because the rubber seal doesn't work, so it's not locked, it's not closing. So this is like contradictory language. So maybe I just want that, it doesn't matter if the technician is saying, because then what there's a reinspection happening because the tenant is claiming that the refrigerator doesn't work properly because the rubber seal is not, it's not sticking, so it's not closing. But then the landlord is saying, oh no, but I have a technician who came out to check and they're saying it's in great working condition. But that's contradictory again. Like how? Because it doesn't seal. So isn't that the function of a refrigerator, to trap in the cold air to keep it, refrigerated? But yeah, so they got that language in there, but yeah, you could push against that. Um, I do like this. It says access dates. So on, August 8th and August 9th from 9 a.m. to 5 p.m. And the cutoff time is 12 p.m. What that means is that, you don't want to be working, you don't want to be in like your home all day waiting for the landlord or the workers. What that means is by 12 p.m., the landlord should have sent the workers or whoever comes. And then if you don't come by 12 p.m., then that means I get to leave by then. So the cutoff time, that's what it means. Now, if they do come, then I have to give you until 5 p.m. So maybe you need to have childcare and you need to pick up your kid by 6 p.m. You can't stay there. So you're giving them till 9 to 5 p.m. And then the completion date. So we have a clear deadline. Okay, September 4th of 2023. You're gonna complete all the work by then. So that's great because then September 4th, if you haven't completed, I can go back into court and say, okay, judge, I can file an order show cause. They haven't fixed this repair that I've been asking for. And this is a clear date. So oh, okay, yeah, go ahead.
Okay, the above caption proceeding is hereby discontinued without prejudice. As petition has been satisfied, respondent provided ledger in court. As we see the highlighted one, hereby discontinued without prejudice, means the landlord has the right to bring a case back against you on a non-payments. This, the way it looks like it's a non-payment case. So if you default again in your rent arrears, the landlord does have the right to commence another case. Petitioner agrees to access and repairs broken fire escape window on September 12, 2023. So as you see, she has a broken fire escape window. They agree to access and repair, meaning they're going to go in on that day and repair it by that day. They're not agreeing to any additional days or time. It's just on that day. Access from 9 a.m. to 5 p.m. Workers to arrive by 11 a.m. So like my coworker said, this is the cutoff time. So sometimes the workers might arrive later, like 11:30 for whatever reason. So it's up to the tenant discretion to see if they're going to allow them to come back in. Because this is a non-payment case and it's discontinued. If this repair is not done by September 12th, it's not fixed within that time, and the landlord's asking for additional time, or the landlord proceed not to follow through with this agreement, the tenant will have to commence an HB action because the case is discontinued. The tenant cannot go back and try to do an order to show cause because it will be denied. This case is discontinued, so the tenant cannot go back to enforce this broken fire escape window. Next slide, please. Proceeding discontinued without prejudice. Again, we see the word without prejudice, meaning the landlord could bring this case again. Has responded, has surrendered possession as of 8/17, which means this tenant voluntarily move out. Petitioner reserves all monetary claims against respondent without including limitation to rent, additional rent, use and occupancy, late fees, legal fees, security fees, and even electric. So this sounds like a holdover case that the tenant probably owned rental arrears. She agreed to move out. She surrendered the apartment, and the condition was that they reserved their rights, meaning they did not waive off their rent arrears or any legal fees, meaning the landlord has reserved his right to sue her in civil court, but also the tenant had preserved her defenses to the same. To means I could sue the landlord because I didn't have these services throughout the time that she was residing there. So in this stipulation, they both have preserved their defenses and the allegations. Next slide. Party agreed disagreement should constitute a lease renewal for each of the terms amount as reflected in paragraph 3 above. Respondent hereby acknowledged the legal regulated rent of the lease renewal has set forth in paragraph 3 and waives any claims, defenses, counterclaims such as amounts which cannot be challenged in any court, administrative agency, or other venue of competent jurisdiction, included but not limited to the DACR. So this looks like a non-payment stipulation. And it seems that this tenant is waiving all her rights, any counterclaims for overcharge, anything at all. This is something that a tenant should try to avoid, not waiving any of her rights to counterclaim or to challenge anything in any other courts or in DACR. If you look at line 6, it says, in further consideration, respondent hereby waives any and all claim defenses and counterclaim raised in the HB action under index number, which is hereby discontinued with prejudice. So you see the word with prejudice means she cannot come and bring this case back on those claims and those defenses. So if she's alleging these repairs, she's not allowed to bring it back because it says with prejudice, meaning not allowed. Either party may file a copy of this agreement on the HB index number for the purpose of discontinuing. So it's not only is they discontinuing her HP action, but she's also waiving her rights to those violations, those conditions. In here, it says respondent alleges. It should not be the word alleges. Respondents state these are the following repairs that needs to be done. The window guards, electricity, and the toilet flush. Have to be a little bit more specifically, like when you say electricity, what is wrong with the electricity? What is not working? If there's a switch that's not working, there's electricity outlet. So you have to be a little bit more specific when you say these are the conditions that need to be fixed. So like that, the landlord said, well, you said electricity, the electricity is working. So you have to be specifically toilet. What's wrong with the toilet? So you have to be a little bit more specifically. Access should be scheduled October 30, October 31st. So this is a stipulation, an agreement that tenants need to be leery of signing. And if they're not understanding, if they were waiving any of their rights, maybe they would like to adjourn the case and try to see some kind of legal information. Next slide, please. Petitioner agrees to put mesh netting in the 3 windows, party to arrange access. Petitioner to allow respondent to park for 1 vehicle in driveway in a manner that allows access for other vehicles. To enter and exit, respondent reserve claims related to pending HP. So this one, in a way, this tenant is reserving her claims regarding to her HP pending action. So she's not waiving any of her right like the previous stipulation. Respondent will pay the petitioner the amount of $1,200 per month beginning June 23 through the vacate date. So this looks like it's a holdover case. By the 1st of every month, except June 2023, we will be paid on June 15. So she had to make sure she paid this rent, and then June's rent will be paid by the 15th. Petitioner waives rent for May 2023, has security deposit will be applied for May 2023. Petitioner will give a dated receipt. So this tenant needs to understand that when she moves out, she will not be getting her rent deposit, which that rent deposit is going to be used for her May's rent. So she needs to understand what's going on, that if she has 3 or 6 months worth of rent deposit, it's going to be used. Next slide, please. Dismiss, no appearance by petitioner without prejudice. So this means the landlord's attorney or the landlord did not show up by the time that they were scheduled to be in court and by the second call. But without prejudice means they could come back, file a motion, and write their defenses on why they were not able to be in court by 9:30 or 10:30. So this case, even though it says dismissed, it could still be brought back. So tenants should understand, no, it's not dismissed. They didn't show up, and the case could be put back on the calendar. Next slide. Oops, what happened? Oh, shoot. Petitioner amended today, I'm sorry. Petitioner attorney unavailable in the afternoon. He had an HPD hearing, proceeding adjourned to February 22nd at 9:30, or day available for respondent for settlement or trial. So in this one, it seems like it's a non-payment. The landlord did not show up. So the proceeding got adjourned for another day. And it's also for settlement. If they don't settle, they don't come to some kind of agreement, that means the case goes then to trial. Usually in a non-payment case, both parties are not agreeing on a stipulation. Maybe this tenant is seeking some kind of rent abatement or wants some kind of things that they're not agreeing upon. So because they're not agreeing, they will go to trial if they're not able to settle on the next court day. Next slide.
Yeah.
That's you.
So those are the examples of our stipulation. Also, I just want to mention for the last slide, when you go to trial, like some people think that a trial will, when you go to trial, the judge will look at the facts of the case. They're not looking necessarily at, like, some people say, okay, well, I need more time. I just haven't been able to, but they look at, do you owe the money or not? If you go to trial for a non-payment case and you lose, so one thing they may say, I'm owed a reduction in the rent because I was without hot water or heat for this much time, and the judge says no to that, or you are not able to make a strong case for that. If you lose, you might only get 10 days to pay. So you really have to see what benefits you, and those are things you may want to, call us to maybe discuss or see what your options are. Maybe it's better for you to do a stipulation. Sometimes it may be better for you to do a trial. You want to speak to a lawyer about that. So those are things. Don't eh, the courts, they don't look at like what you're able to do. They look at like, what is the issue at hand? So is the issue, are you entitled to continue living in this apartment, or do you actually owe this money? Things like that. So these are just some tips, we think will be helpful for a stipulation agreement. When you schedule a time for the landlord to come and inspect, repair, push for a specific time. Example, worker will arrive from 9 to 11 a.m. as opposed to 9 to 5. If you work, cannot be there all day. And remember, if they don't come and violate that stipulation, then you have to go back in tort, which means it's another day you have to take off to file the order to show cause, and then you may have to wait another day if they get a second chance to come and do the inspection or the repairs again. So if you, let's say you start work at 12, you can say, try to push for it. Whatever agreement you guys can come to, like 9 to 11, I think that's reasonable. I'm giving them 2 hours, and that way I can be out by 11 a.m. if I have work at 12. Or maybe that doesn't work for you. You can, if you guys need to um do repairs outside of the 9 to 5 hours, and you can get your landlord to agree to that, yeah, go for it, because maybe that works for you. Yeah. So those are things to consider. And again, you don't have to use the pre-filled out stipulation form. So this is an example of one that's not pre-filled out because it's just handwriting. Other ones this is another example of a not a pre-filled out one that's just people wrote it out. And but this is an agreement that was pre-filled out. And look, there's a lot of things that you're waiving. And unless you know how to read the legal language, essentially you could be waiving things that you don't understand. So a lot of times, this is someone who didn't have a lawyer and they waived their rights and they didn't realize that they waived their rights. So again, like, you have the right to say, no, I don't want to use the pre-filled out agreement. I want to use the blank court ones, and make sure you understand every single line that you're signing. You could say, hey, just give me a minute. I just want to read through it. I want to understand it. You have that right. You just have to be firm, and know, if they're being rushed, you could say, no, don't rush me. Like, I just want to be able to understand this. If you have a question, there is someone called the court attorney. The court attorney, just to be clear, and that's another point we talk about, they are not your attorney. That is the judge's assistant, and they have a different goal than you. Their goal is to try and resolve the case before it gets in front of the judge. So they're going to push for an agreement to be made because they're trying to clear up cases for the calendar. So if you have a question, maybe there's a legal term you don't understand, you can ask them that, but they're not your attorney. Sometimes people think that the court attorney is their attorney because they're nicer than the landlord's attorney. But no, they are not your attorney. They have a different goal than you. The only person who will advocate for you and only your goal is your attorney. Also, sometimes like people think like, hey, the landlord's attorney is being nice, I'm like, well, they could be nice, but again, they work for the landlord. So they're everything they do is going to be in the best interest of their client, which is the landlord, not you. Um, yeah. And if you sign the agreement, make sure you sign it. Some people will be like, I didn't understand what I was signing. I was, like, forced to sign it. It is very hard to get a judge to overturn the stipulation. And simply saying because you are not a lawyer and you didn't understand the legal language, it's not enough. When you go to court, the presumption is, unless there is a hearing held and they've realized that you're not mentally competent, the assumption is that you are mentally competent and you understand everything that you're signing. A lot of people make that claim, like, I'm not a lawyer. Okay, it doesn't matter. You can't, it won't get overturned simply because you're not a lawyer. When you sign something, the presumption is that you understand everything that you've signed. If you, like we talked about previously, like maybe they said, the language, the way So sometimes like, they write out the stipulation agreement and you can't understand anything on that agreement. So what you can say is that I'm not signing this agreement. Like this one, it's a little bit, it's not even actually the worst ones, um, believe it or not. But you may have trouble reading it, and you can ask the landlord or the landlord's attorney who wrote it out. You can be like, I need you to rewrite it. I can't understand this. And then if they argue that no, I'm not rewriting it, I don't have time, things like that, you can go up to the judge and say, like, okay, I'm willing to sign the agreement, judge, but I'm just asking simply that they rewrite it because I don't understand this agreement. You can say that. You have the power to do that. And, the judge doesn't want to clear up the calendar. So maybe they'll look at the attorney and like be like, all right, rewrite it. Or you could be like, hey, okay, well, give me the form. I'll rewrite it. Things like that if they don't have the time. You have your defenses, and again, you can just always feel free to call our hotline. So we have come to the end of the training. So this is actually our number. If you're confused about a stipulation agreement you signed, then feel free to call us. We may be able to look over it and if it's online and see like, hey, what specifically did you sign? We have a hotline staff who speaks English, Spanish, French, and Bengali. And then just in case you have other languages that we don't speak, we do not need you to call us in advance and schedule time. We can connect to an interpreter right away. And these are our social media websites. We have an Instagram, we have a Twitter, we have a Linktree, we have a Facebook, and this training will be uploaded on our YouTube page along with our website, which is going to be listed here. And we have a couple of workshops coming up also. We're listed. We are located we have the hotline, but we are also in the courthouse, and we're there Monday through Thursday. Nobody's there Friday, but we're there 9 to 5, except on Manhattan. It tends to end at 4:30 p.m. Also, when you go to the courts, most courts, you need to get there by 4:30 p.m. the latest, because remember, you need to get through security and they will stop letting in PN. I would say even 3:45 the latest. We have a couple of trainings on this training will be uploaded on YouTube, but we also have other trainings on our YouTube page, like non-payment cases overview, a more in-depth overview of non-payment or holdover case. We have the workshops. And so today we did a stipulation training. We are going to have a future training, I believe, in late April or early May about order to show causes. So the follow-up to this training may be that you need to file an order to show cause. So definitely, we will put that workshop link in the chat and you can sign up for it. And you can also sign up for our newsletter. Yeah, so that's the end of our training. And now we will go through questions. And Tiara is going to read them out loud.
Hello, everybody. Okay, so I collected about 4 questions in total. I'll ask the first one. Um, what can you do if it's a non-primary holdover and the landlord filed a frivolous or fake rent ledger and they try to reverse the former DHCR case decision that certifies that the landlord is using illegal overcharge? Of course, the landlord's lawyer did not disclose this to the courts.
Well, I would say that if you have proof that they're trying to charge you the incorrect amount, you have to bring that to the court. So whenever this is the one thing, whenever you're being taken to court, just remember that this is a claim they're making. They're not saying they're saying this is what I'm claiming is the truth. And then you have to come back and present a defense for yourself. And then the courts themselves will decide what is the actual fact and what is just an allegation. So if you are saying that the landlord is trying to overcharge you, even though there's a DHCR order, you have to answer, never ignore court documents, even if it's a complete like lie, as you're saying, go in and deal with that at court level. Also, when you're taken to court, just remember that sometimes people say, okay, I made an agreement with the landlord. No, if you have court papers, you can make an agreement with the landlord, but you still need to address everything at a court level. So take the DHCR order saying that, hey, this is what the actual rent should be. And then also if you made the payments, you can go there and show that and like, hey, I don't actually owe this rent because this is the amount.
I have a question. This is a rent stabilized apartment. So when you file papers in court, you say frivolous holdover case or is a non-payment?
It
On that
says
question.
it didn't specify that. It just said non-primary. If it's like, I guess I'm assuming a
Yeah, because if
non-primary
he's
is,
alleging non-primary, that means
hmm
it's like it's a holdover case.
yes,
And then
non-primary holdover.
he's probably asking for rent that is not the legal rent in the holdover case.
Right.
Yeah. So I mean, if it's a rent stabilized apartment, he needs to bring it up to the judge's attention. If it's a holdover, you should put your answer in writing, because you still could put it in writing stating this is a rent stabilized apartment. The amount being claimed has rent being owed is incorrect. This is an overcharge, which I have filed a case in DHCR under docket number, and write it down as a defense in the holdover. I hope that answered his question.
Okay.
Also, I just want to say in a primary residence case, maybe whoever wants to call us, because maybe you want some legal advice. Primary residence, essentially, for anyone who doesn't know what it means, is that in a rent stabilized apartment, that apartment has to be your primary residence. So if you live elsewhere or if you file taxes in another place, that could be evidence used against you. So be very careful if you have like a lease elsewhere. It doesn't mean you can't have property elsewhere. It just means that place is your primary residence. So those are things like you may want to discuss with the lawyer about. So definitely give our number a call and maybe we're not saying that we're going to connect you to get a lawyer, but maybe just some legal advice.
Okay. I'll go on to the second question. Is the landlord able to send the tenant to collections without a court decision?
When you say collection, what do they specifically mean to collection? I mean, like,
Collection agent or agency, I believe.
so they file what papers? Did they file papers in a civil case? When you say collection,
I think what they're meaning is that a lot of times, so you might get the rent demand notice letter and it looks like it may have language in there that like it will be sent to collections or something. But I think what that is, so before a non-payment case can be filed, the landlord has to send you a 14-day rent demand notice. And that language tends to have language that either seems like it's an order to get out or it'll be sent to collections. That is standard normal language, but that just means that they're sending the notice that you have 14 days to pay before they're going to start the court case. So I don't know if you're receiving something different, but that notice does tend to have language that it will be sent to collections or whatever.
maybe I think what probably he received was a debt collective letter from the landlord's attorneys that says this is a letter to collect the debt, which is the letter that needs to be served upon the tenant. It says it's a debt collective letter that needs to be paid within 30 days. But it's not that it has been filed with a collection agency. That's a debt collector that actually comes from the landlord's attorney's office, which every tenant gets after they get the 14-day rent demand before the case is filed in court.
Okay. All right, so I'll move on to the next question. If you are evicted by a marshal and your belongings are in storage, what can a tenant do if they are missing any items?
When the marshal evicts you, usually he or she does an inventory of what is in the apartment. And they give you a list if you're there. If you have this list and there's some things missing from the inventory, you probably want to come to court in order to show cause. Ask the judge that these items are missing. If there's any way you could find out what these items are. If not, depending on what decision the judge gives you, then you probably will have to go to civil court and sue them for these damages that you're not able to find or they were broken or damaged. So that's what the person needs to do. But first look at the list that the marshal gave you.
And We have a last question here. Someone wanted to clarify, can forthwith language eliminate the 14-day notice requirement for a martial eviction or marshal's notice?
No. The forthwith language. So when you get a marshal's notice now, there's going to be two dates, the date of service and the earliest eviction date. So let's say the forthwith, let's use the example. So today's March 1st. So let's say you signed an agreement and to pay by February 29th, like $5,000. And it has the forthwith language in there. What that means is that I can just receive the marshal's notice before the payment due date. It won't be after. But what that means is that if I didn't pay by February 29th, and then they had sent me that notice by 14 days before February 29th, March 1st is the first day I can be evicted. Now, if I got the marshal's notice on February 27th, I still need to be given 14 days after February 27th before the marshal can come and evict me. It's just the forthwith language. It's like it allows you to be served before the due date, but then you still need to be served. And it's 14 days from the date the marshal comes and gives you the notice.
Yeah, forthwith doesn't mean that you're going to get evicted. Forthwith doesn't mean that you're not going to get a marshal. It just means forthwith. Landlord's attorney is going to go hire a marshal who's going to come back to the court, request a warrant. It has to be reviewed. It has to be issued, and then they serve you. So they still have to serve you with that warrant, which is the notice of eviction, letting you know that within 14 days, he or she will be at the door, and which is the only way that can be stopped is by you going to court and doing an order to show cause. So that actually was forthwith, meaning they could go and request this warrant right away. Before they send you the marshal notice, they have to request the warrant. And just remember, the only person that can evict you is the marshal, not the landlord's attorney.
Okay. Well, that concludes the question portion.
Okay, well, hopefully you guys, this training was helpful to you. Again, it will be available on our website after this training, both the PowerPoint and the recording. And then we will have some upcoming workshops coming up. So definitely register for those, along with, you can call our hotline 212-962-4795. So we'll put that in the chat. And yeah, everyone have a good day.
Thank you everyone for coming. I hope you had a nice time and enjoyed the training. Get home
Thank you,
safe.
everyone. Take care.
Thank you.
No problem. And again, if you have any clarifications, always just feel free to call us. Maybe if you need clarification on your stipulation, we have our number. We're still open today.
Take care,
And just a
everybody.
reminder, our information table are open Monday to Friday between 9 and 4:30. So if you have a tenant that needs to go to court, we are there Monday to Thursday. I'm sorry, I said Friday.